I'm Wayne Pollock. I'm a thought leadership ghostwriter serving big law and boutique law firm partners and executives at companies that serve the legal industry. I help these partners and these executives boost their prominence and their authority one word at a time. Sometimes attorneys are concerned that a piece of thought leadership that they are going to write could be used against them down the road by opposing counsel. If you're ever concerned that this could happen to a piece of content that you're planning on writing, well, you can do this one thing to avoid that problem. Pretend you're in law school and argue both sides. This fear of thought leadership being used against them comes up for attorneys who could be on both sides of an issue based on their practice. So if you're a corporate litigator or you are a family law attorney, what you might be arguing one day regarding a case or a statute, you might be arguing the opposite later that week, that month, or that year with a different client who's on a different side of that statute or on that case. When you're concerned that's going to happen, the easy way to avoid a potential situation down the road where opposing counsel uses your piece of thought leadership against you by citing to it in a brief, a motion, or something else is to simply play both sides. After you've walked through a case, after you've walked through a piece of legislation or some administrative agency action, or even best practices for doing something, at that point, when you begin your analysis, just go on both sides of the fence. Explain why the case, the legislation, or the administrative agency action could be interpreted one way, and then argue the opposite, just like you would during a law school final exam. What you want to do is make sure you've covered all of your bases. So if the article is ever cited against you, you could simply say, well, I was discussing both sides of the issue, just like we used to do in law school. I was giving my audience an idea of the full spectrum of possible ways that this decision, this legislation, this administrative agency action could be cited or used in litigation down the road. Now remember, you're still providing analysis. You're still providing guidance and insights. You're still engaging in thought leadership. You're explaining the so what and the now what of that case, but you're just playing both sides to avoid that piece of content being used against you down the road. Now, if you have the kind of practice where you are always representing the same kinds of clients, such as plaintiffs in consumer rights actions or defendants in consumer rights actions, then you are not going to have to worry about this. You're always going to argue that a statute or a court decision should be interpreted a certain way because that certain way will be consistent with all plaintiffs or all defendants. Don't let the fear of a piece of thought leadership content being cited against your client stop you from writing that piece of thought leadership content. If you're ever concerned that a piece of thought leadership content you're contemplating writing could be used against your client by opposing counsel down the road, simply harken back to the days when you were a law student and argue both sides in your analysis portion of that thought leadership content. If you're interested in learning best practices for legal thought leadership, regardless of which side of an argument you come down on, check out lawfirmeditorialservice.com. We have plenty of videos, blog posts, and podcast episodes that can help you do just that.